answered. But with that, we're going to start off with the DA, my DA here in El Dorado County, Vern Pierson. So I'll turn it over to you, sir.
Thanks, Sean. Good afternoon, everyone. Just a little historical perspective. So the traditional cash bail in California is the name it's been generally referred to, is in many respects governed by two initiatives back in the early 1980s, actually 1982, most notably referred to as Prop 8 being one of them. And just very generally, they were provisions that were very pro-law enforcement that said public safety is a primary consideration, the harm to the public. And there's been a little bit of changes, but those were, some of the provisions were built into the California Constitution, and they've been, with some other statutes, 1269, 1275, they've largely governed the way bail has been handled and over the last many years. And then over the last several years, as I'm sure you're all aware, there's been this movement here in California and elsewhere. I'll just basically describe it as it's a movement to say that there really should be significant limitations on pretrial detentions, or maybe even no pretrial detentions, and that there's a big push on that. There was a bill, SB 10, that was introduced in the legislature. Through the process of negotiations, it changed fairly significantly, building in some things having to do with public safety and recognition of some people that are arrested and not yet convicted are in fact dangerous. And many of the supporters were not so much, either went neutral or were not so much in support of it anymore because they didn't like those changes. The bail agents, they were very strongly opposed to that change in SB 10. And so they brought forward the mechanism to have the measure placed on the ballot in November, and that for consideration by the public to decide whether or not that law should go into effect. And it's a statute that essentially says, without getting all the weeds of it, essentially says that the cash bail system is a thing of the past, that there needs to be determination based on risk. And if you are considered dangerous, you stay in custody without bail. If you're not, then you should get released on your own recognizance. That's very generally the way it was portrayed. And then moving forward to February and early March of this year, March and April of this year, with the coronavirus, the Judicial Council got together, and on April 6th, they issued an order that looked at a whole category of crimes, serious and violent felonies and things like that, and said, okay, for those people, things stay the same. For everybody else, and it's a wide variety of misdemeanors and some felonies, with those people, their bail, as far as the bail schedule is concerned, is reduced to 0. And so that went into effect. There was a period of time where the people that were in custody, there was determinations that need to be made with them. And then you went over to the new arrests and how those are being dealt with, and whether or not they should have 0 bail, they should have no bail, or they should have bail with conditions. And that's kind of the history of how it got us here. There's been a couple of cases. Maybe I'll turn over to Jim, who's going to talk about the most recent case out of San Diego and its relevance to this.
Thanks very much, Vern. So when this emergency rule number 4 originally came out and set a presumptive $0 bail schedule for what are known as included offenses, which is Vern just mentioned, is essentially all misdemeanors and certain felony offenses, either deemed serious or violent felonies. There was some confusion about what the law meant, the rule meant, and specifically the purpose of the rule is set forth there and says, notwithstanding any other provision of law, you are supposed to apply $0 bail to the included offenses. It set forth that presumptive schedule in any event. And the exceptions, if you read the letter of Emergency Rule 4, appear to be pretty limited, i.e. you can only deviate from it if there were a couple of constitutional provisions that came into play, one of which being Article 1, Section 12, or Section 28F3 of the California Constitution. So those are very limited in their effect. One allows you to set a no bail for somebody if you can prove that by clear and convincing evidence that they're likely to engage in violent actions or criminal activity in the future and so forth. So initially, when the language came out, it seemed to be fairly broad in its scope and fairly limited in its exceptions. And fortunately, we just received some guidance from a District Court of Appeal out of the 4th District in a case called Ayala versus Superior Court. And in that decision, the District Court of Appeal said, well, yeah, we see that language notwithstanding any other provision of law, but it's our interpretation of this emergency rule is that it was set forth by the Judicial Council in harmony with pre-existing rules and statutory schemes governing bail in general. Accordingly, under, I think it's Penal Code Section 1269C and Penal Code Section 1275, you can actually deviate from the standardized bail schedule in a county. And in this case, the Ayala court says same thing for the statewide bail schedule set forth in Rule 4. So if there are the underlying facts and circumstances which would cause you to believe that it's appropriate to deviate from $0 bail, even on one of those included offenses, then you can do so. You have to go in and make your case in front of a magistrate, either pre-arraignment with the on-call magistrate, or alternatively at the arraignment with the magistrate and or judge who's hearing the case for arraignment. And you make your case for a bail deviation. And specifically look at factors such as whether or not, somebody's criminal record, for example, if they have a history of fleeing, failing to appear in the past and so forth. So those are kind of some of the things that you can look at to further public safety and or to ensure the appearance of the defendant at future hearings and during the course and scope of the case. So I'm putting out, my office putting out a client alert on the Ayala decision here either later on today and or tomorrow morning. So to get a more detailed discussion of the law. And I don't want to bore you with those details, but that's kind of where things are. So anecdotally, I represent a number of law enforcement agencies and associations throughout the state of California. And one of the questions that I've been posing, which I think goes to some of the questions that we received, such as, is anyone having any luck for requests for increased bail? One county, that San Bernardino County, I've spoken with the district attorney there. He has indicated that they're doing approximately anywhere from 6 to 8 contested bail hearings where they are seeking an upward adjustment on the bail from $0 bail to something else on one of the included offenses. And those are hearings in which the DA is making his or her case, defense counsel is making his or her case as to why it should remain at 0, and ultimately the judge is making the decision whether to stick with the statewide presumptive bail schedule set forth in Emergency Rule 4, or alternatively, pursuant to those penal code sections, adjust those bail upward to reflect the circumstances of the case before them. And the San Bernardino County DA has indicated that in the vast majority of those cases that they're bringing to the court, which they're exercising that option judiciously, but in the vast majority of those cases, they are getting a bail adjustment based on the facts and circumstances and the situation that they're dealing with. And Vern, I'll kind of kick it back to you for a minute. I do have some other anecdotes I'd like to share, but I'd like to hear your experience as the DA in El Dorado County.
Well, thank you, Jim. Our experience has, it's always nice when a court comes out and interprets something exactly the same way you would interpreted it. So there's some degree of validation there. We interpreted the emergency rule the same way. And working with our courts and in conjunction with our public defender, before it actually went into effect on that Monday in early April, we indicated that we were going to do two things. One is work with Sheriff's Department to evaluate those that were in custody. And then two, as new cases came in, we would be working with the on-call judge, contact the on-call judge and say, Judge, this person has been arrested. We understand that they fit within the category of the $0 bail. We think you should deviate from that. And if the court deviates from that, then and issues a bail at some amount or no bail, then we're outside of the $0 bail requirement. And that has been the way that's been working here. I was just on the phone a little while ago with Greg Totten, the DA in Ventura. And I think that that's in a significant number of jurisdictions, that's the way it's being interpreted, but not all. So, and I probably, the sheriff is probably a good one to speak to in terms of what the other sheriffs are seeing on that side of it, because particularly they did handle the ones, a big number of people in terms of that were in custody without convictions prior to the rule being passed and going into effect.
Thanks a lot, Vern. I just would like to share an anecdote. This zero bail experimentation, which may become ultimately the law depending on whether or not the ballot measure passes, kind of unraveling. It was SB 10 you mentioned, Vern, which was presumptively taking us statewide on a more long-term basis to $0 bail. But here's an anecdote from a county, and these are telling to me, quite frankly. A suspect was arrested on April 2nd for a series of 8 burglaries in this county, including several schools, a car rental agency, as well as arrested for possession of a loaded firearm and committing a burglary during a state of emergency. The suspect was released on his own recognizance on April 7th. On April 16, the suspect was arrested again following burglaries in the city, including taking cash registers from another city, additional burglaries in a third city, and theft of a total of 23 vehicles. The arrest involved a vehicle pursuit in which the suspect drove on the wrong side of the freeway and which resulted in a collision. Subsequently, the suspect was released on $0 bail. That to me is frightening, folks. I mean, that is essentially what I would characterize as a crime spree. This person, because he did not commit any offenses that were excluded from $0 bail, got cut loose. Another anecdote, on April 19th, the suspect was arrested for auto theft after an officer nearly saw him drive into a lake. He was released on $0 bail and committed a carjacking 40 minutes later, approximately a mile from the jail. Thereafter attempted a second carjacking. Police officers then located the suspect trying to open the door of a building. The suspect ran but was ultimately arrested with the assistance of a police canine after attempting to kick and injure the canine. And I could bore you with 100 such anecdotes from jurisdictions throughout the state of California. But those I think are just illustrative of, in my opinion, the travesty of the $0 bail system is being completely taken advantage of by those who are criminal minded. And quite frankly, I pray that it does not result in the law of the land come November. So with that, I think I will, unless there are any questions, I'll turn it over to Sheriff Magrini, who certainly has the on the street knowledge about how to apply the $0 bail schedule in emergency.
Thank you, Jim, and thank you, Vern. I think that was a really good brief on how we got to where we are. And I think it warrants some clarification that this didn't come from our local superior courts. This is a judicial council that made this ruling back in April 6th that really forced this upon us. I know CSSA was opposed to this and wrote a letter as such, even though the Judicial Council did not acknowledge that letter and stated they'd received no communication from many groups, which was not factually correct. But make no mistake, this is the platform that they used COVID-19 to launch, and some of the reasoning was to protect the health and safety of inmates, the court and law enforcement personnel, and the public. And what they did was exactly the opposite of that by forcing this upon us. In fact, we had to work to establish people that were currently in custody that had to be released and that were ordered to be released. In fact, one of my, if you will, a level of protection was I got an order from the court ordering the release of the inmates that we currently had in custody that fell within the preview of zero cash bail as a just layer of protection. But we did work with our district attorney, public defender, and the courts, and were able to mitigate that list down significantly to what we initially identified was a very high number. We were able to bring that down to a very lower number. Several of those ended up being heard by the courts, and we won most of those, but I think of 2. So in the end, what does it mean for us on the street? It means that we have our duty to go out and to make arrests, to use proper discretion and judgment on when we make those arrests, knowing that some of those might get booked and subsequently released right away, but nonetheless, we're still solving the problem on the street and removing somebody from the environment that would be dangerous to just release them with a cite letter or with a criminal fine down the road. We do, as has been pointed out already, at least I think most jurisdictions have a form through their DA. If not, please converse with your DA through a 1269C, a request for bail increase to this emergency bail schedule. We have implemented a training bulletin that went out to both our jurisdiction, our agency, and the other jurisdictional agencies on how that would work for when you do book somebody. And as has been mentioned already, does require an on-call judge if after hours, similar like a probable cause declaration where you identify the charges, the reason you think that person is still against the safety of the victim, or to ensure the defendant will show or is a danger to the public. Based on that, you make your declaration, your pledge, or your attestation to the judge, and then hopefully he grants that increase in bail further than obviously a zero cash bail. I have heard of several of those being done already with some level of success. In fact, locally, I don't know that any of our judges have denied any of those requests. So I think that was one of the questions in the queue, is anyone having any luck with a request for increased bail? And the answer to that is yes, from what I've heard from deputies and officers on the streets and other colleagues in the state, that local judges are hearing those requests for increased cash bail and are granting them. The other question is, how long is the zero bail expected to run? As has been said in this, this was given under the preview of COVID-19 to help our jails, although that's the last thing it did, because now we release those people, and as we heard Jim touch on already, where they were essentially in quarantine. They were in our jails already. They had been there pre-COVID, and now we had to release those people. They're going out into the community, getting exposed, getting rearrested numerous times, and potentially bringing back the potential for a COVID exposure in our custodial facilities on a daily basis. So although it's very frustrating, it is set to last 90 days after the governor lists his stay at home or his declaration of state emergency. And this is SB 10 that was set to go to the ballot in November by Senator Hertzberg. So this is something the voters are going to vote on come November, and it extends 90 days after whenever this ends. So we can assume by design this is going to push right up against our November ballot. So what we are asking, the state sheriffs, myself locally, my ask is all of you, is to please track these numbers. If there's anything to be taken away from this thing that was forced upon us, is to track how it is not working so that we can use it. There's a Californians for Safer Communities coalition that's been stood up already. I personally have joined it along with many other sheriffs, and we want to be able to use this data as kind of a, if nothing else, to use as a test run, a test drive to show the voting in California is that this does not work and it is not safe for our communities. So please do us all a favor, and as you see these repeat offenses, let your department administrators know. Hopefully they're communicating, I know they are, with their local sheriffs, and we'll be using that data to support this California for Safer Communities coalition.
So I want to throw up our second poll question while I'll throw out some of the questions seen in the chat, if any of our participants can respond to it. So let me throw up the second poll question. The response to the first one about who's had to petition their magistrate, it was about 72% that said they haven't yet. This next question is regarding the guidance that you've received. I think it's been brought up that there needs to be constant communication. So if everyone could take a moment to answer the second question about what type of communication you've had from your partners, even leading up to zero bail or this whole situation or not. So a couple questions that came for those who have been arrested and have a history of FTA, and is that history taken into consideration in denying zero cash bail? Does zero bail apply to domestic violence or child endangerment charges? So I'll see if anyone has an opportunity to answer those two questions while we wait for all the responses on this poll question.
So I can answer the domestic violence. That still does have a bail to it. However, I'm looking at this cheat sheet I have in front of me now. However, corporal injury to child, for an example, battery against elder or dependent adult, battery against a peace officer. I mean, there's just several here that are all zero cash bail. So very, very concerning. And I've shared this with our local media sources so they have an idea of just what we're up against as they see these repeat offenders continue to recidivate and victimize our local communities. It's not because of a lack of effort by the great work by all of our sheriff deputies and police officers throughout the state who, for me, I feel like my biggest challenge is trying to keep motivation and keep people directed to fighting a good fight, because we all continue to do good work every single day and not get discouraged by what gets forced upon us at a state level.
Yeah, I appreciate what the sheriff was saying, and just to add on and maybe touch on something that Jim was talking about, some of the anecdotal stuff, and I know Ventura County is one historically that's very good at record keeping, and so that's why I wanted to look at some what they have. So I was talking about 10851 and the impact of Ventura County in the 6-week period following the order going into effect. They had an 85% increase in vehicle thefts over the year before for the exact same period of time. That's a very dramatic increase. And additionally, what they're saying is that I think it's roughly 8% of the people who are being released on $0 bail have been rearrested and are in custody on new charges within 3 weeks or less. That's just a very short period of time, and they're continuing to track that. And I think that's going to be consistent with across the state of California of these arrests and rearrests. This whole concept of not detaining someone prior to conviction, and frankly, some people would like to never detain anyone even with a conviction. But New York had the similar type of experience, except for unlike California, where we went to a referendum in November, theirs went into effect. And what happened was within a very short period of time, the legislature had to act and/or the governor to repeal and greatly modify a very similar measure when they had specific examples of someone doing the classic no weapon displayed bank robbery and going to do a bank robbery and then be released because there was $0 bail at that point in time, and then go and do another one and another one and another one until and it received a significant amount of publicity. Now that's separate from the emergency order. Theirs was the same type of measure, which is on the November ballot, that would make this be a similar type of approach, be the actual law of the land as opposed to a temporary measure, which is what we're still working under the emergency bail order from the Judicial Council.
One of the questions I saw pop up here, it says, Yeah, and I think it's important, if we didn't say it already, that this applies to all misdemeanors. All misdemeanors have that zero cash bail. And then a substantial mark, it's probably easier to figure out the felonies that have bail than is it those that don't, unfortunately. But one of the questions was, for those arrested and have a history of not showing up to court, is this history consideration? That's a very good question. The things that we put out in our training bulletin that the deputy and or officer, depending on jurisdiction, need to articulate is the defendant a danger to the public and or victims, and the belief that the defendant will or will not show up to their next court. So those are the things that we have communicated with our judges that they have asked for in consideration that we provide to help them make a decision on whether or not to increase from a zero cash bail. So again, I think it's important to reiterate, is that person still a danger to the public and or to the victim, or victims, plural, and is there a belief that the defendant will not show up to his or her court date? So that is what we have told, is what will help the judge make the decision on whether or not to increase that cash bail.
Thank you all. I'll throw open the opportunity for anyone to unmute themselves to ask any questions of any of the panelists. I did put in the chat box the link to the coalition that the sheriff mentioned that's been brought to CPOA as well. Our endorsements task force is making a recommendation to our board of directors as well. But as he mentioned, a number of individual sheriffs and law enforcement groups have already signed on. So I'll open it up to anyone if they have any questions to go ahead and likewise unmute yourself and feel free to ask. If folks may still be unmuting, what I'll mention too is it was interesting. One of the roles I play at CPOA is our lobbying and government affairs. And when this bill, SB 10, was coming forth last year, it was interesting through its various stages. You had groups like the ACLU and others who normally are on complete opposite side of where we are, and a lot of issues were completely all for SB 10 when it was going through, saying we need to get rid of cash bail. It went through some different, language changes about giving counties some more ability and judges some more opportunity to make a decision on this, and it completely switched their position on the bill, and they actually opposed it in many of the committees in the Capitol. And it was presented by Senator Bob Hertzberg of kind of the Van Nuys area, who has a history of these kind of FTA related issues. He's the one that in the past said, hey, if you have a bunch of FTAs, you can pay half your fines and just be okay, you'll be forgiven. And as you may recall or may know, that a lot of those court fees and FTA fees helped fund the Peace Officer Training Fund as part of POST. And so POST lost a huge chunk of funding in addition to the funding that was just being wiped away from the budget from the general fund and the legislatures and the governor's budget. So POST took a huge hit, and all the things that were being asked of POST, to do this and do that, they were losing a huge revenue stream because of that. And so he has some other, issues. So one of the questions was brought up is, depending on what happens on the ballot in November, is it possible that bail could come back? If it does, I have a feeling as long as folks like him and some of these colleagues are in the legislature, they'll continue to fight it, at least from what I've seen. So it's definitely an interesting time, but I think what needs to be echoed is what the sheriff said, is that you need to use the knowledge that you have to make sure that your public and your communities are aware of how dangerous this can be when it comes in November. One final question that just popped up: is anyone seeing an increase in ankle monitoring as a condition of bail? Any responses? Anyone seeing anything?
I think we've had a number of them. And kind of the way our approach was that we were not going to, given the way the order was written originally, we were not going to ask for that as a condition. Instead, we were going to say, this person's dangerous, that we think they should stay in and get an order from the court, but that the defense attorneys would come in and say, Judge, would you consider an ankle monitor as a condition in order to release them? And I think, and our probation office is really big on those. So I think as a result, there's been a small number of increase for those in our jurisdiction. I'm not sure about beyond that.
Yeah, and we too, I mean, we have several pre-sentencing tools, PSOR, the ankle monitoring program that we administer both through probation and through our jail. But I don't know that these would qualify. So to answer that question, no, I am not aware of any increase in electronic confinement or electronic monitoring, just due to the fact these are zero cash bail. Then once they come in, unfortunately, it's that revolving door mantra that they go right back out. And there's no pre-trial or pre-sentencing risk assessment. We have several tools related to that we're not able to utilize now. This also has a big detriment on any MAT or medical assisted treatment programs that might be within the facility, and a lot of other tools that we have that we've tried to utilize. This diminishes our ability to utilize any of those.
Another question came up: is CPOA, PORAC, and others prepared to saturate Sacramento with factual data, noting all of these things, increases in crime and ongoing behavior? And so I can only speak for CPOA, but the answer for us at least is yes. It's part of our legislative platform that our board, including Sheriff Eric Magrini, who sits on our board, and Jim as well, that approved, was to provide factual data on all public safety and all criminal justice reforms. So with use of force reforms of late, everything we've put what's been in DOJ's own crime report, as well as some other reports about what everyone's been reporting at the local level, to tell the story and just say, hey, put the brakes on because you need to go off the data, and here's what the data is telling you. So we plan to do the same with this. And again, I'm only speaking for CPOA, who I can speak for.
And I want to add that the other very frustrating part of this is, it's our job as sheriffs to obviously run a custodial facility, run the jail, detention facility, and we were at maximum capacity and have been under a court cap order here in Shasta for releasing those when we get to a percentage. As of last Friday, we were at 69%. So that's how much. Granted, it does have an impact on that. Activities down, calls for service are down, bookings are down. But now our ability to hold people and hold them accountable, at least until they get to an arraignment and or a prelim, have been chiseled away as well. So it's having a horrible impact on our custodial facilities that now have room to hold these people accountable, and we can't even utilize it.
And I'd just like to kind of follow up on one of Sean's observations for CPOA. We have been saturating Sacramento for a number of years with facts, statistics, and so forth, in an effort to try to persuade the legislature to act in a certain manner, i.e. to foster public safety. The unfortunate thing is, at least in my experience, and Sean, I welcome your comments on this, is many times it falls on deaf ears. The political agenda overrides facts, logic, and essentially everything else in many instances. And really, it just doesn't make a difference in many different circumstances, unfortunately. So thus the coalition, get out the vote, spread the word, kind of a grassroots type campaign, get people out there voting on these things to essentially nullify these legislative efforts to undermine public safety by way of the will of the people. I mean, that's what propositions are there for, is to the ultimate expression of the will of the citizens of California. So let's take advantage of it for a change to promote public safety.
Yeah, and as I mentioned, what CPOA, one of our plans is to put forth a voter guide to educate these legislators public, so that they're the ones calling and saying, hey, Senator, Assemblyman, we need to go this way on this. But just to educate them as well as they go to the polls, whatever the polls for this pandemic may look like in November, whether they're mailed in or whatnot. But going to the polls, we'll do our best to educate the public that we can and share our resources with the profession and our members to make sure that you have some, especially if you can let CPOA and the coalition kind of speak for it, since you may not be you may not be able to as an agency, but we'll help get you the resources to help educate the public to on these trends. So hopefully they make the right decision when it comes in the fall. So if there are no final questions, I'll wait. Yeah, go ahead.
One brief comment. It's really just agreeing with what you, Jim, and Sheriff Magrini indicated. There is one side benefit, always trying to find the silver lining in something that's terrible. This is kind of run as a test where, in theory, the Judicial Council put this order together thinking that these were the least dangerous people, least likely to offend based on the categories of what they were. If we're able to gather the data and use the data to go back and say, look at what happened with these people. Now they want to do it on a broader scale. And that's what this ballot measure or the referendum will be about in November. I think we probably can make a more compelling case. It's not just the sheriff's opinion or the DA's opinion. We're saying, this is our opinion. We predicted it at the time. The sheriffs were very aggressive about saying, this is going to cause a big problem. And this is what happened. And we were right. And so now to expand it beyond is really a problem.
So if no other final questions, we thank you, gentlemen, for your participation and your time today. And again, just encourage everyone to keep reporting what you're doing, keep obtaining the information that you're doing, because that will help tell the story, as was just mentioned. So with that, we thank our facilitators for their time today. Thank you for tuning in, and hope to see you next time.
Our pleasure. Thank you.
Thank you.